That's all right. We'll do it.
Okay. A juvenile delinquent is a person over what years old and less than how years old? Over 7.
Over 7 and less than 17.
17. Yup. That's why I did this, man. You can't confuse the shit out of us.
Okay, here we go.
You go.
3. Blank means the temporary care and maintenance of children away from their own homes.
I know the answer. Do you know it?
I do. Go ahead.
Detention?
Yep.
Okay. 4. Detention of a person alleged to be adjudicated as a juvenile delinquent shall be authorized only in facilities certified by blank as a detention facility.
Is this Division for Youth?
Shit, I forgot. Let me look. Division for Youth.
Okay.
I
5.
have to remember that. Detention is Division for Youth. All right.
We'll just keep going over it.
Okay,
5.
next question.
Blank
Blank
means... No, I'm doing this one.
Oh.
Blank means a hearing to determine whether the respondent committed the crimes alleged in the petition.
Don't tell me. Blank means a hearing.
I know this one, so you don't have to look at the answer.
I don't know it. Wait, blank means a hearing.
Do you want multiple choice?
No. Let me just take a second. Blank means a hearing to determine whether the respondent committed a crime. Fact finding?
Yep.
It is?
Yep. It's too much time.
Yeah, let's move on. Number 8. Blank means a designated felony act that would constitute a Class A felony if committed by an adult. Blank means a designated felony act.
Designated Class A felony act.
Oh, yeah. Okay, that makes sense.
Okay, number 9. Blank means the agency or authority which is responsible for presenting a juvenile delinquency petition.
Presentment agency.
Good.
10. Blank means a respondent who, as a lack of mental illness, who as a result of mental illness or intellectual or developmental disability lacks capacity to understand the proceeding against him and to assist in his own defense.
Incapacitated.
Oh my God, I'm remembering that we did these questions, remember?
Some of them, that's why I'm glad we're going over them again.
Yeah, but some of them are not coming back. Okay.
Okay, 11.
You go.
11. Blank means an initial hearing or subsequent hearing for the purpose of reviewing the foster care status of the respondent and the appropriateness of the permanency plan developed by the Commissioner of DSS or the Office of Children and Family Services.
Okay, I remembered it because you said permanency. So is it a permanency hearing?
Yes.
Would they put that in the question?
I don't know.
The initial
Just
hearing?
remember, this is, I think, how they would put it in the question.
Yeah, that's kind of a key word.
It's reviewing the foster care status.
Foster care permanency hearing. Okay. 12. The family court has exclusive original jurisdiction over any proceeding to determine whether a person is a juvenile delinquent.
Yes, true.
We remember that. Okay, we just did that. Okay.
Yeah. Okay.
Oh, I was thinking for a second that we were thinking about the court order deterring endpoint.
Okay. 13. This is 302.2. JD proceeding must be commenced within the period of limitations prescribed by 30.10 CPL, or unless the act is a designated felony, commenced before the respondent's blank birthday, whichever occurs first.
Okay, so.
This is a 2-part question, so do the first part.
Okay, so a juvenile delinquency proceeding must be commenced. Juvenile delinquency has to be commenced within the period of limitations. Okay, I remember that. Or, unless it's a designated felony, commenced before the 18th birthday?
Yep.
18th birthday, okay.
Now, when the alleged act constitutes a designated felony, such proceeding must be commenced within such period of limitation or before the respondent's blank birthday, whichever occurs first. So now this is a
21st?
20th.
20th?
Yeah.
It's 20th. How am I going to fucking remember that?
I don't know, but look at your answer key.
I'm going to put a star next to that one.
Okay.
It's 18th or 20th. So we're talking about JD proceedings commencing them, right?
Yeah, this is like statute.
Must be commenced before, if it's not a designated felony, right?
Yep.
So not, let me put the word not here, not a designated felony, it's 18.
Yep.
If it is a designated felony, if such constitutes a designated, I'm going to put is a designated felony, such proceeding must be commenced before his 20th birthday. Okay, that was good for us to go over.
Yeah, yeah.
I'll remember it the next time, I hope.
I think you will.
This fucking test has a lot of birthdays and shit in it.
I know, the ages is so annoying.
Okay, next question. 14, a juvenile delinquency proceeding shall be originated, filed in blank, in which the act in the petition allegedly occurred.
The county.
Probably you're right. Let me just check, but I'm sure that's the county. Yep.
Okay.
Oh, you go.
Effective, this is 304.1, effective October 1st, 2018. A facility certified by blank as a juvenile detention facility must be operated in conformity with the regulations of blank.
Okay, so I think I remember this one.
Okay.
It's not the Division of Youth. This is the one where it has to be certified by the something of Child and Family Services.
The Office of Children and Family
Office of
Services.
Child and Family Services as a juvenile detention facility and must be operating in conformity with the regulations of the Office and Child Family Services.
Yes.
16. The detention of a child under blank years of age in a secure detention facility shall not be detained under any provisions of this article. I forgot this.
10.
It's 10.
Yeah.
A child under the age of 10.
So in parentheses, that's 9 and younger.
Wait, at least 10 is in a secure detention facility shall not be directed under any of the provisions of this article. So what does that mean? They can't stick a child under 10 in jail?
Yeah, 9 and younger.
So let me write that here. So they can't put a kid 9 and younger.
Right.
So under 10. Okay.
Yeah.
Let me put that in my answer key so I know when I look at it. So 9 and younger, they can't put in jail. No jail.
No jail for 9 and younger.
Good. I'm glad you brought that up.
Okay.
That's why I did that. Because it's easier for me to remember. Like if a question comes up on this, I need to write in the sidebar 7 to 16. You know what I mean?
Yeah,
So
I know.
I just need to see that because when they start saying less than in 2019 and not in 2018, I'm like, oh God.
I know.
And
All right, wait, let me keep going.
I believe, is not criminally responsible for such conduct by reason of infancy, or is the defendant in an action ordered removed from a criminal action?
From a criminal court, it says.
Oh, criminal court, sorry.
Okay. All right, your turn.
2, a juvenile delinquent is a person, I think I just reiterated this.
That's all right. We'll do it.
Okay. A juvenile delinquent is a person over what years old and less than how years old?
Over 7 and less than 17.
17. Yup. That's why I did this, man. You can't confuse the shit out of us.
Okay, here we go.
You go.
3. Blank means the temporary care and maintenance of children away from their own homes.
I know the answer. Do you know it?
I do. Go ahead.
Detention?
Yep.
Okay. 4. Detention of a person alleged to be adjudicated as a juvenile delinquent shall be authorized only in facilities certified by blank as a detention facility.
Is this Division for Youth?
Shit, I forgot. Let me look. Division for Youth.
Okay. 5.
Remember that. Alleged. Okay. I go?
Yep.
Blank means a hearing to determine whether a respondent requires supervision, treatment, or confinement.
Dispositional hearing.
Now, to me, a dispositional hearing would be like the end of the case.
Not in this thing.
But in this.
Oh my God. Oh God. This is the question from hell. I'm so glad that you're getting it.
The next one?
Yep.
Okay.
Effective October 1st, 2018. Designated felony means an act.
Oh, I'm so glad that are you reading this off the computer or did you print it?
No, I'm reading it off my phone.
Oh shit, it's so nice when it's printed out on your phone. It must be so hard to read.
No, it's not. It's good.
No?
Nope.
Okay.
All right. So,
To get in our head, you see if you look down, the 14 to 15-year-old one and is missing, and this one is missing 13-year-olds. The robbery and assault. The burglary is missing 13 and 16-year-olds. It's very confusing.
it's horrible.
I don't even really want to go over this right now. Do you want to?
No, let's just skip this one.
Because we know it's all race.
I'm gonna go with the other than a misdemeanor thing because I want to just read this one.
Go ahead,
Other than, all right, so assault in the second, robbery second degree by a person 14, 15, 16, and then in 2019, 17, but only where there's been a prior finding by the court that such person committed an act which would be assault second degree, robbery second degree, or any designated felony act, regardless of the age of the person at the time of the commission of the prior act, other than a misdemeanor committed by a person 7 to 16 or 7 to 17, but only where there's been 2 prior findings by the court that such person committed a prior felony act.
Right.
Okay.
Oh gosh.
That's you know what? I'm okay getting one of those wrong.
Move on. Number 8. Blank means a designated felony act that would constitute a Class A felony if committed by an adult. Blank means a designated felony act.
Designated Class A felony act.
Oh yeah, okay, that makes sense.
Okay, number 9. Blank means the agency or authority which is responsible for presenting a juvenile delinquency petition.
Presentment agency.
Good.
10. Blank means a respondent who, as a lack of mental illness, who as a result of mental illness or intellectual or developmental disability lacks capacity to understand the proceeding against him and to assist in his own defense.
Incapacitated.
Oh my God, I'm remembering that we did these questions, remember?
Some of them, that's why I'm glad we're going over them again.
Yeah, but some of them are not coming back. Okay.
Okay, 11.
You go.
11. Blank means an initial hearing or subsequent hearing for the purpose of reviewing the foster care status of the respondent and the appropriateness of the permanency plan developed by the Commissioner of DSS or the Office of Children and Family Services.
Okay, I remembered it because you said permanency. So is it a permanency hearing?
Yes.
Would they put that in the question?
I don't know.
The initial.
Just
hearing?
remember, this is, I think, how they would put it in the question.
Yeah, that's kind of a key word.
It's reviewing the foster care status.
Foster care permanency hearing. Okay. 12. The family court has exclusive original jurisdiction over any proceeding to determine whether a person is a juvenile delinquent.
Yes, true.
We cover that. Okay, we just did that. Okay.
Yeah. Okay.
Oh, I was thinking for a second that we were thinking about the court order determinant.
Okay. 13. This is 302.2. JD proceeding must be commenced within the period of limitations prescribed by 30.10 CPL, or unless the act is a designated felony, commenced before the respondent's blank birthday, whichever occurs first.
Okay, so.
This is a 2-part question, so do the first part.
Okay, so a juvenile delinquency proceeding must be commenced. Juvenile delinquency has to be commenced within the period of limitations. Okay, I remember that. Or, unless it's a designated felony, commenced before the 18th birthday?
Yep.
18th birthday, okay.
Now, when the alleged act constitutes a designated felony, such proceeding must be commenced within such period of limitation or before the respondent's blank birthday, whichever occurs first. So now this is a
21st?
20th.
20th?
Yeah.
It's 20th. How am I going to fucking remember that?
I don't know, but look at your answer key.
I'm going to put a star next to that one.
Okay.
It's 18th or 20th. So we're talking about JD proceedings commencing them, right?
Yeah, this is like statute.
Must be commenced before, if it's not a designated felony, right?
Yep.
So not, let me put the word not here, not a designated felony, it's 18.
Yep.
If it is a designated felony, if such constitutes a designated, I'm going to put is a designated felony, such proceeding must be commenced before his 20th birthday. Okay, that was good for us to go over.
Yeah.
I'll remember it the next time, I hope.
I think you will.
This fucking test has a lot of birthdays and shit in it.
I know, the ages is so annoying.
Okay, next question. 14, a juvenile delinquency proceeding shall be originated, filed, in blank, in which the act in the petition allegedly occurred.
The county.
Probably you're right. I just checked, but I'm sure that's the county. Yep.
Okay.
Oh, you go.
Effective, this is 304.1, effective October 1st, 2018. A facility certified by blank as a juvenile detention facility must be operated in conformity with the regulations of blank.
Okay, so I think I remember this one.
Okay.
It's not the Division of Youth. This is the one where it has to be certified by the something of Child and Family Services.
The Office of Children and Family Services.
Child and Family Services as a juvenile detention facility and must be operating in conformity with the regulations of the Office and Child Family Services.
Yes.
16. The detention of a child under blank years of age in a secure detention facility shall not be detained under any provisions of this article. I forgot this.
10.
It's 10?
Yeah.
A child under the age of 10.
So in parentheses, that's 9 and younger.
Wait, at least 10 is in a secure detention facility shall not be directed under any of the provisions of this article. So what does that mean? They can't stick a child under 10 in jail?
Yeah, 9 and younger.
So let me write that here. So they can't put a kid 9 and younger.
Right.
Under 10. Okay.
Yeah.
Let me put that in my answer key so I know when I look at it. So 9 and younger, they can't put in jail. No jail?
No jail for 9 and younger.
No jail. Got that. Okay. Next question. Who goes?
You go.
Okay. A detention facility which receives a child under supervision of this part shall blank notify the child's parents and other person legally responsible for his care if such legal responsible person is not available to whom the child resides and that he has been detained.
Immediately.
Right. You go.
Okay. Wait, did I skip one?
I don't think so.
Oh wait, no, I think you just went twice.
Oh, okay.
Okay. So,
We can remember this. You're going right now on number 18, right?
Okay, yeah, but you know what? I wanted to ask you a question that I read in the family court rules.
Okay.
Can I? Okay. So, this is about designation of a facility for the questioning of children charged in juvenile delinquency.
Oh, okay. So wait, before you go on, can we just back up? Didn't we do this in CPL? Questioning a child, you can do it at his house.
Yes, this is the question I'm going with.
Okay, am I remembering this?
Yeah.
Okay.
Yep.
Okay.
Okay, and there was one other place.
Oh, don't tell me. The child's house or
It's a place designated by the.
parent?
No, this is a governmental agency.
The probation?
By the Office of.
Of Family and Child Services?
Yeah.
Motherfucker. Alright, so read me it again without blanks.
Okay, so it has to be in a place approved by the Office of Children and Family Services or.
Wait, just read me the whole question like it was going to be a question on the test.
Oh, I didn't make up a question. I just wanted to go over this because we're doing this kind of thing.
We're talking about the questioning of a child.
Questioning of a child, and this was in the CPL. I don't remember what article it was, but it had to be a place that was certified by the Office of Children and Family Services, or it could be in the child's home.
Okay.
With the child's parent or a legally responsible adult.
Okay. Good. I'm glad you brought that up.
Okay.
I need to hear that. Okay.
All right, now you go.
No, you go to number 18, and this I will do. You do the even numbers, I'll do the odd numbers.
I know, but I thought I was doing the odd numbers, so I cheated and looked at the answers on them.
I'll do 18 then. Okay. Upon application of the presentment agency, the court may issue a TOP against the respondent. When they say against the respondent, they mean mean an order of protection protecting the respondent or not protecting the
No,
respondent?
protecting some other person.
From the respondent.
Yeah.
Oh, against him. Okay.
Yeah.
Now I got it. Oh my God, sometimes things just don't click in my head. For good cause shown, ex parte, or upon notice, A, at any time after the juvenile is taken into custody. B, or upon issuance of a what? C, or upon the filing of a petition. What is a blank?
Is it? I think I know this. I think I know it. Is it an appearance ticket?
Mm-hmm.
Family? Oh no, it's a family court appearance ticket.
Family court.
Family court appearance. Fuck.
You know what? Let me put a check next to that.
Yeah, because if they put appearance ticket on the test.
Actually, now it's coming back to me, man, that when we did this, you said, put a check next to that. And I said, I can't because I'm reading it off the computer.
Yeah. Okay.
All right, so I'm going to put check next to that. And then it goes on to say, a temporary order of protection may contain any of the provisions authorized in making of the order of protection. Temporary protection is not a finding of wrongdoing. And a temporary order of protection may remain in effect until blank is entered. I don't know.
An order of disposition.
Oh, I was going to say disposition, but it's a order of disposition.
All right.
Remember, what?
You'll remember. We're just gonna keep going over them. Just put a star next to anything that you didn't know.
Yep.
All right.
All right.
19. I cheated on this one because I didn't remember it, but whatever. Hopefully you'll remember it.
I'm not going to look at the answer.
Don't look at the answer. I was only checking the answers on the ones that I thought I was asking you.
Okay.
So 19. This is 305.1, effective October 1st, 2018. A private person may take a child under the provisions of this article for committing an act that would be a crime if committed by an adult into custody. In which cases can this private person, in the same cases where a private person can arrest an adult for the crime under 14030 CPL. Before taking such child under the age of blank into custody, a private person must inform the child of the cause thereof and require him to submit, except where it was, the hot pursuit.
Right.
Okay, now,
Hot pursuit.
yeah, so now that this is a two-part question. So answer the first part. What age? This is the part I forgot.
So I want to say the first age that came to me was, I was going to say 14, but then I said 15. Is it 15?
I think it's 16.
16?
I just looked at the answer 5 seconds ago and I already forgot. But I'm like 90% sure it's 16.
Fuck. Hold on. It's 16, motherfucker.
All right,
Check.
so, yeah. Okay, after such person takes the child into custody, the private person must take the child without unnecessary delay to A, the child's home, B, family court, C, police officer, D, peace officer.
Okay. I'm going to say it's only A and B. No?
No,
It's all four?
it's all of them.
Fuck. Alright, I go. For purpose of this section, the word officer means...
Police or peace.
Okay.
Okay, this is effective October 1st, 2018. An officer may take a child who may be subject to the provisions of this article for committing an act that would be a crime if committed by an adult with or without a warrant in the cases when he can arrest a person.
Without.
Yeah.
Okay. I take my questions straight from the book. Do you think they're good?
I think they're really good.
Because I literally do not change any words.
Yeah, and you know why it's good? Because even though like we don't have like confusing multiple choices on them most of the time, we're answering them without any choices. It's like everything's fill in the blank.
Yes, that's why I like doing it like that.
Yeah.
You want to know the answer cold.
Yep, you want to know it so it doesn't matter what they put.
The question, we can go right to the answer.
Yeah. Like that one you did with the support order, you really got me on that one.
Oh, I don't even remember which one it was. Oh, it was something about a child support.
Yeah.
Something about what takes precedent over certain cases.
Yeah, it was in criminal, and it was like
something like that.
it was
We'll
something
go over it
stupid.
again eventually. We'll have to go. We'll have to do a marathon of my Oh, you know what? I took fucking 3 Saturdays off in a row from doing hair.
Oh, awesome.
So I'm gonna be able to stay home from like 7 in the morning till 10 at night to study on Saturdays and Sundays for like 3 weeks in a row.
Oh, good.
So,
I'm glad.
Yeah. All right. Who goes? 21.
I go. Okay, so this is in.
22. I go.
Oh, you go. Okay.
22. If an officer takes the child into custody, or if the child is delivered to him, he shall blank notify the parents or person legally responsible for the child's care. If such legal responsible person is not available, the person with whom the child resides or who the child has been taken in custody. When?
Immediately.
Right.
Okay. After making every reasonable effort to give notice, the officer shall A. Release the child to the custody of his parents or other PLR upon the issuance of a blank to the child and the person whose custody he's released, or
I'm going to answer that part first.
Okay.
A family court appearance ticket?
Yes!
All right.
Okay, so... Or, effective October 1st, 2018, forthwith and with all reasonable speed, take the child directly.
I should have blanked that out and made that a question for us to remember.
Oh, I think I'll remember it because it's just so ridiculous. And without his first being taken to the police station house, to the family court in the county where the act was allegedly committed, or when family court is not in session, to blank.
The most accessible magistrate.
Yep. Unless the officer determines it is necessary to question the child, in which case he may take the child to a facility designated by the fucking chief administrator as a suitable place for the questioning of children. Or so this is why I picked this out, because it's different in criminal than it is in this.
Okay.
So in this one, it's a facility designated by the fucking chief administrator, but in the criminal one, it's the Office of Children and Family Services or whatever the hell it was.
Wow. Okay.
Okay.
Let me underline facility designated by the chief administrator. Okay, go ahead. Moving on. Or?
As suitable questioning for the place of children, or upon a consent of the PLR or parent to the child's residence and question him there for a reasonable period of time.
Okay, so this is saying that if the cop cannot, take the kid to...
If the family court is not in session. So, but the thing is that if they don't say that, like if they give us a question, where does the cop take the kid? The first answer you have to look for is the family court.
Family court.
Okay, so if it doesn't say...
If the family court is not open, and it's open, then it's the most accessible magistrate.
Right, and then it's the most accessible magistrate. So... If the county is, so it's the county where the act was allegedly committed, and if that, I guess that family court's closed, then the next answer would be the most accessible magistrate, and then only if the officer determines it is necessary to question the child.
Oh. Right.
Okay.
Unless he wants to question him, then he'll take him to a facility designated by the chief administrator.
The fucking chief administrator or the child's home with consent of the parent. But I think that if they were going to make a question out of this, they would try to trick us by leaving out the questioning part and they would do like 1, 2, and 3, and 4, and you would be like automatic to choose all of the above.
Right.
But it wouldn't be all of the above. It would only be family court.
Or
the most accessible magistrate.
Because he would only take him to the facility designated by the chief administrator if he wants to question him.
And if he determines it's necessary.
Right.
Okay, so it would have to be necessary to question him.
Moving on.
All right, C. Or take the child to a place certified by the blank as a juvenile detention facility.
Family services?
I thought this one was Division for Youth.
Nope, it's the Office of Children and Family Services.
Oh my God, this is the question I asked before, and I fucking already forgot it.
Yup.
So this is the same. Okay, so this is where they're marrying the criminal. Then, because in criminal, I think it says the Office of Children and Family Services.
Okay.
So it is consistent.
Okay, so it is the Office of Family Services, and that designated chief administrative one is only if he wants to question them.
Yes.
Okay.
For the reception children. Okay,
so they can take him to a detention facility.
Yeah, so this is weird because the way that they put it, they should have put it in order.
Yep.
They could have put it in order better. They could have said, take the child to the family court. If family court's not in session, the most accessible magistrate, or to the Office of Children and Family Services for the reception children.
Available. What's the next one?
Oh, I don't remember this one.
Short-term safe house.
Oh, that's right. And the next one is short-term safe house.
But he has to consent.
Yeah.
Let's put a check next to this one.
Yeah, because this one is all, like, it should be written as the questioning thing should be at the bottom of all this.
Wow.
And it would be easier to memorize.
So why don't you read that from the get-go with all of the correct answers?
All right, I'm going to do that. Okay, so effective October 1st, 2018.
Don't leave anything out. Read it with everything in it with all the right answers.
After making every reasonable effort to give notice, the police officer shall release the child to the custody of his parents or other PLR upon the issuance of a family court appearance ticket to both the child and the person to whose custody the child is released, or effective October 1st, 2018, forthwith and
so
with...
he doesn't have to bring him to the family court. He can do one or the other.
Right.
Give him an appearance ticket.
Yeah.
He doesn't have to. That's like not the number one answer.
Yeah, but this is if he's not going to give the appearance ticket, and if he was not, okay, so
go ahead.
Okay, so or if they couldn't find anybody to come pick him up. All right, so without his first being taken to the police station house, take the child directly to the family court in the county where the act was allegedly committed, or when family court is not in session, to the most accessible magistrate, or take the child to a place certified by the Office of Children and Family Services as a juvenile detention facility for reception of children, or take the child to an available safe house, or if it appears that the child is sexually exploited and the child consents to be taken, he could take the child to an available safe house.
Right.
Unless
if the officer wants, unless
it's necessary to question him, then he could take the child to the child's home if the parents consent.
Right. That whole section should have been at the bottom.
Yep, it should have been at the bottom. Or to a place certified by the fucking chief administrator for the questioning of children.
Yeah. So the court gonna get to those rules.
I don't know. I made like a video on it. That's why I remember it pretty well. But so the place gets certified, and like there's something in the rules about how it has to also be approved by like the administrative judge for the family court in New York City. So if it's in New York City, the place has to be like approved by that judge.
Okay.
All right.
All right, next question, moving on. 24. The following the arrest of a child alleged to be a juvenile delinquent, 7 to 16, or the filing of a delinquency petition involving a child who has not been arrested, the arresting officer or appropriate police officer or agency shall take or cause to be taken fingerprints of such child if the child is blank years older, and the crime which is the subject of the arrest or which is charged in the petition constitutes a Class A or B felony, or the child is blank years of age or older, and the crime which is the subject of the arrest or which is charged in the petition constitutes a Class C, D, or E felony. I do not remember these.
Okay, I think I'm gonna guess these. I think the answer.
Okay, go ahead. You
So
guess.
so. All right. So for the A or B felony, I for some reason think it's 10 or 11.
Oh fuck! I think it's 11. I think.
Is it 11 year? It's like 11.
It's ringing a bell.
I think it's 11. And then for the next one, I think it's
It ups it. Right?
13.
Like
I think it's 13 for the next
I
one.
want to think it's like 2 years older or something.
Yeah, I think my guesses would be 11 and 13. And please
It
don't.
is.
Yes.
It's 11 and 13, girl.
Fuck yeah. Okay. Next.
Right, I'm gonna put a check.
Put a star next to that one. Yeah. Okay.
I am because I can't remember right away. The next time we do it, I might get it.
You will. 25. Upon receipt of a fingerprint report from DCJS, the recipient officer agency must properly transmit blank copies of report
Copies.
to the family court in which a proceeding may be originated, and blank copies to the presentment agency
Copies to the presentment agency.
who shall furnish blank copy
One
to.
copy to the respondent.
And this is different than in criminal court, because in criminal court, we have to give it out. Like the court has to give it out. Remember, like in arraignments?
Yeah. The second half of this test, we're going to be like, what the fuck? But maybe if we can get together again tomorrow and do it again.
Yeah.
Okay. 26. Who's that? Me?
Yep.
A family court appearance ticket is a written notice issued and subscribed by A, a peace officer, B, a police officer, C, a probation service director or his designee, or D, the administrator responsible for operating a detention facility. Or why can an administrator of a detention facility do it?
Because if the cop takes to the kid there.
Okay. All right, you go.
Okay, 27. If the crime alleged to have been. Okay, I'm going to say this with their language because they must have fucked up here. If the act alleged to have been committed by the child is a designated felony, the return date shall be no later than blank, excluding Saturday, Sunday, and public holidays, after the issuance of such family court appearance ticket.
Okay. Read the next part, and then I'm going to think about it again.
Okay. If the crime alleged is not a designated felony, if the act alleged is not a designated felony, return date shall be no later than blank after issuance of a family court appearance ticket. I looked at the answer, so I know.
I'm going to guess. Let me guess.
Okay.
I don't remember, but I'm going to guess. Is it 72 hours is the first one?
Okay, what do you think the second one is?
14 days?
You're right about the second one, but I got to double check the first one.
I'm right.
Oh, yay. Okay. I forgot after 2 seconds.
2 hours or 14 days. So if it's a really bad designated felony, they got to do it fast. They're going to do it in 72 hours, which is how many days is 72 hours?
But you know why that's so confusing is because it says excluding Saturday and Sunday and public holidays, but they're measuring it in hours.
Right. That's true.
So that's stupid.
All right.
Because I thought the answer was the next day family court's in session, and then, whatever. But in no event later than 72 hours.
That's going to come up, I think, in another question.
Okay.
But this, we're talking about appearance ticket. Let me underline appearance ticket. Maybe that's a trick in this question.
Okay.
The other one might be something else, like a summons or something.
Yeah, maybe. I don't remember.
This is an appearance ticket.
Yeah.
So I underline appearance ticket. Maybe that's the trick.
Okay.
You want me to put the check next to it? Yeah, because it is a time frame one.
Yeah.
All right. You go. No, I go.
No, you go.
No, I go. Okay. A copy of the family court appearance ticket shall be forwarded by the issuing person or agency to the complainant, B, the respondent, C, the respondent's parents, D, the appropriate probation service within blank after issuance. Oh, fuck. I don't know. Within...
Oh, my God, Ange, hold on. We got to back up to that other question.
Okay.
Because the trick in it, you were right. The trick in it is the appearance ticket.
Okay.
It's that's what it is. It's that's what makes it.
You know, it's funny in my test. If you notice, I don't normally use italics words.
Yeah.
But in my test, I italics the words after issuance of a family court appearance ticket.
Yep. Okay. Because that's what made it like.
72 hours or 14 days.
Yep.
Okay. All right.
All right. Go ahead.
A copy of the appearance ticket, if any police officer, peace officer, probation service, or administrator issues an appearance ticket.
I know this one.
Okay.
You have to give it to the kid, the parent, and the probation service, and the complainant, the person that's there.
Who's the complainant? Oh, the person that says he punched me.
Yeah.
Oh, okay. And then the kid that punched him, and the kid that punched him's parents, and the probation service.
Yep.
But within how many after issuance? Within how long after issuance?
Oh, I don't know.
That's the second part of the question.
I don't know this one. Just tell me. Oh, wait, let me look it up.
I don't know. I didn't look at it either. I'll guess too. You guess.
I'm gonna guess. All right, so if the other way, if it's returnable 72 hours, I'm gonna guess 24 hours.
Oh my God, that's so funny that you think like that because I didn't even think like that. If it's returnable and but wait, if it's a designated felony. Oh wait, what'd you say? If it's returnable in 72 hours?
No, 24 because the other thing is
72 hours.
and and you didn't have a double question in this, so I'm guessing that
Okay.
you know that's why.
4 hours, you bitch. You're so smart to even think like that. Well, if they're going to issue the appearance ticket and it's got to be back in 72 hours, they're not going to forward it in 2 days.
Yeah, because then they'd be giving the person like notes. You know, I knew it had to be less than 72 hours.
24 hours. Okay, next question. You go.
All right, let me go. Did you put a star next to that one?
Yes.
Okay. 307.3, question 29. The agency responsible for operating a detention facility shall or may release a child in custody before a petition is filed to the custody of his parents, PLR, person he lives with, when the events occasioning the taking into custody do not appear to involve allegations the child committed a delinquent act. Shall, correct. I'm so glad you got this one because this is also in the rules.
Oh, really?
So I knew this one. When practicable, such agency responsible for operating a detention facility shall or may release a child in custody before filing a petition to the custody of his parents, PLR, person he lives with, when events occasioning the that he was taken into custody do involve allegations the child committed a delinquent act.
That's May.
Yep. I should have asked them out of order, but okay.
That's okay. You're right. That's okay, but it made sense when you read it first. That made sense. If you would have read the second one, I would have probably had to think about it a little longer.
Okay.
They do appear that there's allegations. Well, if they do appear, then they shall take them. You know what I mean?
Yeah.
That's what I would have thought. Do appear allegations committed. Do not appear. They shall release him. Oh no, you're right. They're talking about releasing him. Right?
Yeah, you got him. You got them right.
I got it right. Okay. Next question. If a child is released under this section, the child and the person legally responsible for his care shall be issued what?
Family court appearance tickets to appear at the probation service.
Oh shit! There's 2 answers to that.
No, I'm just no. I don't know.
Family court appearance ticket.
Okay, effective October 1st, 2018. If for any reason agency does not release a child, such child shall be brought before the appropriate blank, or when family court is not in session, to blank. Oh, there's a lot of blanks.
Before the appropriate family court.
Yes.
Or when the family court is not in session, to its most accessible magistrate. Go ahead.
Okay. Provided, however, that if the family court is not in session and if the magistrate is not available, such youth shall be brought before such family court within blank or the next day court is in session, whichever occurs first.
Within, is it 24 hours?
Well, think about it. It's, well, are you guessing or you know?
I don't know.
I think it's 24 hours.
Oh, I'm just, because I'm thinking if they're saying if the agency does not release the child, they have him in custody, they got to do something with him fast.
Right. So
That's
I believe the answer is 24 hours. So such agency shall thereupon...
No, it's 72 hours.
Oh my God. Okay. All right.
Check.
Big check, big star next to this one.
Because my logic was thinking, well, they did the first sentence, they're saying they're not releasing him. So what are they going to do? Take him home for the weekend?
No, I'm
like, they got to take him fast.
Do you know what's the dumbest thing about this? All they need to say here is they should bring the child to family court on the next family court day, period.
Right.
That's what it should say. Okay, next, let me read. Okay, so when the family court is not in session and the magistrate is not available, such youth shall be brought before such family court within 72 hours or the next family court day, whichever occurs first. Such agency shall thereupon file an application for an order of this part and shall forthwith serve a copy of the application upon the appropriate presentment agency.
Okay, that is presentment agency, right? Yep. Okay, so basically what they're saying is they're not releasing him. They either got to bring him to the family court or the magistrate. And if the magistrate isn't available, then he has to be brought before the family court within 72 hours, or the next day it's in session. And then what agency shall file the application? The cop?
It says such agency. They're talking about the agency, the detention facility. The agency responsible for operating the detention facility. That's the agency.
Is going to file an application for an order?
I don't know what the hell that means, but
what kind of order?
I don't know. Let me look it up. This is 307.3.
307.3, letter number 4, little number 4.
All right, this is blah, blah, blah. 72 hours next day. Effective October 1st. This says, the most accessible magistrate as designated by Appellate Division and Supreme Court. However, if the magistrate is not available, the family court, whichever sooner, for an order pursuant to 307.4. All right, so I got to look at 307.4. What the hell?
I usually do cite things in my questions.
Yeah, I know.
Usually I didn't do that on this. Wait, what's the number? I want to put it on my test.
Okay, so it's 307.4, a written application, and the judge shall hold a hearing for a preliminary determination of whether the court appears to have jurisdiction over the child.
Oh, okay, so it's an application to see if there's jurisdiction.
Yeah, which makes no sense, but whatever.
All right, next question.
I think they're really looking for a detention order. I think that's what they're talking about, but whatever.
And I also think the thing we have to remember is the 72 hours. If they're not releasing him, and they don't bring, if they bring him to family court and that doesn't work, and they bring him to a magistrate and that doesn't work, then within 72 hours of the next day, the family court's in session.
Yeah, and we have to remember that it's now the most accessible magistrate designated by the Appellate Division.
Yes, it's always the Appellate Division, isn't it? This shit.
Yeah.
Okay.
All right, so let's go. Next is you.
If a child in custody is brought before a judge in family court before a petition is filed, that probably means like by an appearance ticket, right?
Or this is if the cop arrested him and family court was open.
Okay. Upon a written application, a judge shall hold a hearing for the purpose of making a preliminary determination of whether the court appears to have jurisdiction over the child. At such hearing, the court must appoint an attorney to represent the child if independent legal representation is not available. Provisions 320.3 and 341.2 shall apply in such hearing. At such hearing, the judge shall order the release of the child to the custody of the parent or PLR or for his care if A, court does not appear to have jurisdiction, B, does not appear to he have committed a designated felony act, C, appears to involve acts which constitute juvenile delinquency unless the court finds and states facts and reasons to support detention.
I'm going to go with A and B.
Yeah, because C doesn't sound right. If he did a juvenile, if he was if he
please yeah, I hope that's right.
Let me go look at 32. Let me see what the answer is. It's A, B, and C.
What?
It doesn't make sense because they're saying appears to involve. Maybe appears to involve.
Oh my God.
A juvenile delinquency. That's like murder and shit. Oh no, that's a juvenile offender.
Yeah. Okay.
A juvenile delinquency.
So this is like maybe graffiti, like stupid stuff.
Okay. All right. So let me just read that really quick. If a child is in custody is brought before a judge in the family court before a petition is filed, cop brings them or there's an appearance ticket, the judge is going to hold a hearing for the purpose of making a preliminary determination of whether the court. So it's about jurisdiction. Right away, the cop brings them and they're going to have a quick preliminary determination of whether or not they have jurisdiction. At the hearing, the court must appoint an attorney, and the hearing, the judge shall order the release of the child to the custody of his parent if he does not have jurisdiction, if he does not appear to have committed a designated felony act, or appears to involve acts which constitute a juvenile delinquency unless the court finds and states facts reasons that supports it. That could be a really trick question.
Yeah, this is a terror. I hate the way they write things.
That could be a really question they could say appears to involve acts which can constitute a juvenile delinquency, and I would think right away no.
We just got to remember that when it says, if they're saying juvenile delinquency and they're not saying felony acts or designated felony, they're probably it's stupid stuff, probably.
Not that bad, right. But that's why I was thinking, right away I was thinking it was bad.
Yeah,
right.
No, you got to think of, like, if it says designated felony, then it's bad.
Right.
If it says this,
then... That makes sense. And you know what? The next time I read this test, it's going to make sense. And hopefully if we see it on the test, it's something that I'll get.
Like, I'm going to think of it like he was making graffiti or he had a joint or something stupid.
Yeah.
And that's why, they're saying the judge has to release him.
33.
Okay, so hearing shall be held within blank of the detention or the next day court is in session, whichever occurs first. I looked it up so you could guess.
All right, okay, so now the fucking officer's got to get him there within 72 hours.
Right.
Once he gets there, the court has to hold this preliminary hearing.
Yeah.
Within...
And it's within the time the detention commenced. That's when it's measured from.
Oh.
It's not measured from when he gets to family court. It's measured from when the detention commenced.
From when the police got him.
Yes.
Oh my God. Within... I don't know. I'm gonna guess. Oh my God. I can't even think of the answer.
You're gonna scream when I tell you.
I'm screaming already. All right, I'm gonna say they gotta do this hearing, the preliminary hearing, within 4 days.
Oh, I think it's 72 hours.
I just made a stupid answer.
Let me just check. Let me
72 hours?
70, I'm gonna check. Hold on.
I'll look up the answer. Hold on.
Okay.
But it's good that you have the book and look it up too.
Yep, 72 hours.
72 hours. Okay, so the cops gotta get him there within 72 hours, and the preliminary hearing has to be within 72 hours.
Or the next day court is in session, whichever is first.
On both of them.
Yep.
All right, so that's good. We're still in the beginning stages of when the little punk gets picked up. And so far, the only time frame we have is if the police takes him and can't bring him to the family court or to the magistrate, he's got to get him to the family court within 72 hours.
Yes.
The family court now has to do a preliminary hearing within 72 hours.
To see if they have jurisdiction.
For jurisdictional reasons.
Yes.
Okay. We got it, Nat.
Okay, I don't know either of the next two questions, so go ahead.
Me?
I'm going to guess. Yeah, go aheed.
All right. Thanks, Joe. Present the application at the hearing.
Is it the presentment agency?
I was gonna, you know what I was gonna say? I was gonna say it might not be the presentment agency because they're not really involved yet, right?
You would think they're not involved yet, but this is family court and everything's stupid in it.
I'm gonna say presentment agency. I'm gonna say,
I mean, who else could it be?
I'm gonna say an officer. I don't know. It's gotta be the presentment agency. Yep, it's the presentment agency.
Okay, I don't know the next one either, so hopefully you do. 35. A petition shall be filed and a blank hearing shall be held within blank of conclusion of the hearing.
A petition shall be filed.
And a blank hearing held within blank of conclusion of hearing.
Is it a probable cause hearing? No.
I have no idea. I'm gonna have to look up the answer.
Within blank of the conclusion of the hearing? I don't know. I'm just guessing.
I don't know. I'm gonna look it up.
I'm right. It's probable cause hearing.
Wait. So read it. Read it with the whole answers in it.
Oh, wait, you're gonna die when you hit the time frame.
Is it 4 days?
Yes.
Yeah, I'm looking at it right now.
A petition shall be filed and a probable. So wait. Now they're talking about. There's no such thing as an appearance ticket. We're talking about that didn't happen, right?
There's no appearance. This is not an appearance. This is when he was brought to the family court.
And a petition was filed?
Yeah, because they have the hearing pursuant to the section, the hearing about the jurisdiction.
Okay.
And then they're saying that now they're I guess they're saying that there's got to be a petition filed.
Okay, so I think the trick to this question to me right now is the very last sentence when it says, of the conclusion of the hearing. of the conclusion of the
Jurisdiction hearing.
preliminary hearing, right?
Yeah, preliminary jurisdiction hearing.
Hold on, I want to write that here. Preliminary hearing. So that kind of makes sense now. At the conclusion of the preliminary hearing, if they find out the little punk is going to be charged, that's
They
when
have to file, then they have to file this petition.
Okay, so then they have to file the petition, shall be filed, and when the petition's filed, they're going to have a probable cause hearing.
Within 4 days
of the preliminary hearing. What's the probable cause hearing do? Do we know yet? I mean, we might go into it next, but
I'm guessing it's the same thing as a felony hearing in criminal. You know, like the what do they call it? The felony hearing.
Yeah.
In Article 180, I think it's probably the same thing.
Okay, moving on. I can't wait to do this test again.
I know, and we know all the answers. Yeah.
Right? Go ahead.
I think you're up. Or am I up? I'm up.
36 made me. It's even.
Okay, you go.
Upon finding of facts that support detention order. So that's an order. The court shall determine and state in any order directing detention, A, whether whether the continuation of the child in the child's home would be contrary to the best interest of the child. B, where appropriate and consistent with the need for protection of the community, whether reasonable efforts were made prior to the date of the court hearing that resulted in the detention order issued to prevent or eliminate the need for removal of the child from his home. Or if the child had been removed from his home prior to the initial appearance, where appropriate and consistent with the need for protection of the community, whether reasonable efforts were made to make it possible for the child to safely return home.
And I know that's A, B, and B.
Yeah, I guess I don't think I put a C next to that. I think I messed up.
That's all right. Well, it's all of them. Well, that's true.
Yeah. So
all
basically, what are they saying? That if the facts find that they have to detain the kid,
well, this is
they shall determine.
If he orders detention, he has to say he has
whether the continuation is in the best interest of the kid.
And if it's not because like his parents are two like hot messes, then he's gonna say that. Or if he says the community is at risk.
Okay.
Or
so it's basically gonna just give us reasons what they are.
Yeah, which it would be so much easier if they would just write that in the fucking statute, but whatever. All right, 37. A proceeding to adjudicate a person a JD is originated by, and we know this one.
Is it the presentment agency?
Yes.
Okay. Hold on, I want to get to my answer key page so I can look for the answers too. Okay. No, it's not presentment agency. The answer is not presentment agency.
It's not?
A proceeding to adjudicate a person, a juvenile delinquent, is originated by...
Oh, filing a petition.
Yes.
Oh, okay. But if they had multiple choices, we would know.
It would be presentment agency.
And then it's only a presentment agency can originate it, though.
Right, but it would make sense either way. The answer could fit either way.
Yeah.
Okay, 38. Only blank may originate a juvenile delinquency proceeding.
All right, well, presentment agency.
Okay, you go.
Okay, 39. If the appropriate agency does not originate a proceeding within blank of receipt of notice from probation service, it shall notify in writing the complainant of that fact.
Okay, so if the appropriate agency does not originate proceeding, what do you mean the appropriate agency?
Well, it's the presentment agency, but you have appropriate so that it would be not a question.
But is that in the book, appropriate?
No. You just put that in there probably so that you didn't give away the other answer.
Oh, but I want to know, is presentment agency in the book?
Hold on, let me look.
It is.
I'm sure it is.
It's little 3. 310.13.
Okay, yeah. So, all right, go ahead. What's the answer?
Presentment agency in the book?
It says presentment agency.
It does?
Yeah.
Let me write that up.
Oh, no, I'm sorry. It does say appropriate agency. But it's saying only a presentment agency and this one right before it.
Okay. If the I'm going to write presentment agency anyway. I like writing on my notes.
It's the appropriate presentment agency, I guess.
Right. It's if the appropriate presentment agency does not originate a proceeding within blank of receipt of notice from probation, it shall notify in writing the complainant of the fact. So the presentment agency has to originate it within, I don't know,
30 days.
30 days?
That's what the answer says, yeah.
God, I got to put a check next to that one. But what are they exactly saying?
That we don't want to file a petition.
How did the probation officer all of a sudden get involved?
Oh no, the probation service, because you know a family court appearance ticket, they're returnable at probation. They're not returnable at the court. They're returnable at probation.
If it's an appearance ticket?
Yeah, so then the probation service has to tell the presentment agency, okay, we did our assessment.
Oh, I didn't know it was returnable in probation.
Yes.
An appearance ticket doesn't go to the family court, it goes to the probation?
It's at a probation service, yeah.
Oh, I didn't
They don't
know
call
that.
it probation, they call it the probation service. So I'm guessing it's in family court, it's just called the
Okay.
probation service.
Okay, so the probation service have to tell the presentment agency to file the thing.
And the presentment agency is like, fuck you, probation service, I don't have to listen to you. So I don't want to file this petition. And they have to
Okay.
tell the complainant within 30 days that they decided not to file the petition.
Okay, that makes sense. Okay, I got it.
Okay?
Yep, 40. After petition has filed or upon order of removal, the respondent is entitled to what?
Now this is like a blank, so it could be a bunch of things because he's entitled to counsel.
Yeah.
He's entitled to hearing to determine whether there's
A lawyer.
yeah, there's all kinds. So I need
Answer
choices.
is a speedy fact-finding hearing.
All right, so it's a speedy trial, but they call it a fact-finding hearing.
Yeah, but I should remember that because they can trick me up and put something else like a probable cause hearing, and I'll be like, okay, that sounds right.
But he's also entitled to have a probable cause hearing.
Oh, okay.
But the key word, I guess, is speedy fact-finding hearing.
That's what it says. Speedy fact-finding hearing. Okay, you go.
Okay, a petition to originate a JD proceeding is a written accusation by a blank.
Presentment agency?
Yes.
Okay. 41, right? Okay. A petition shall charge at least one.
Act if committed by an adult would constitute a crime.
It only said crime.
Well, again, they're so inconsistent. It's either a crime or it's an act, but most of the time they call it an act.
In the book, it said crime.
Yeah, that must be like something they haven't updated since the 60s.
Okay. Well, I would put crime if that was the answer on the test, right?
Yeah.
Okay. All right, you go. 43.
Petition must contain. Okay, so do you want to try to guess some of them?
Well, I pretty much know that it's all of them because I
Yeah.
made the test. So why don't we just read them what the petition can contain, and
All
I'll
right.
just listen to you.
I'm going to try to abbreviate as
Oh,
much
wait,
as possible.
You see where 10.118 is?
Yes.
That means that C is added.
Okay. So name of family court, title of the action, 10-118, that the respondent is a person of the necessary age to be a JD at the time of the alleged act.
And that's what is the J? What is that age?
16 or 17 next year.
Right, 7 to 16, right?
A separate accusation for each act or crime charged, the precise act or crime charged, a statement in each count that the crime or act was committed in a designated county, a statement in each count that it was committed on or about designated date, a plain and concise factual statement in each count without allegations of an evidentiary nature, supporting every element of the act or crime charged, the name, if known, of any other persons charged as co-respondents in family court, or the name of adults in criminal proceedings in the commission of the crimes, a statement that the respondent requires supervision, treatment, or confinement, and the signature of the presentment agency.
I think I just have to read that 100 times.
Yeah, you know what? I feel like we would recognize these on the test.
I hope so.
I think we really would.
I hope the things that they try to throw us off with are just ridiculous. That we'll realize that that's just ridiculous.
Yeah, or it's going to be something that we don't recognize at all because we're going to have read everything. So
Right.
we're going to know because we're going to be like...
You are going to have read everything. I don't read everything. You're much better with the reading than I am.
Ugh.
Okay, I go. A petition shall be blank in accordance with the CPLR.
Shall be blank. Shall be in conformity. I don't know.
Verified.
Fuck. All right, put a big star next to that one.
That could be a trick.
That's a tricky one. Yeah.
Petition shall be verified.
Yeah, definitely put a nice star there for me.
Okay. You go.
Okay, 45. If the petition alleges that the respondent committed a designated felony act, it shall state and term in quotation marks shall promptly be marked thereon.
Oh, I know it. Is it as a designated felony act?
Yes. If allegations of a designated felony act are dismissed or withdrawn and the respondent is found to have committed crimes, or I'm going to keep saying acts, which are not designated felony acts, the term designated felony acts shall be stricken from the petition.
Got it. It's actually, I looked at the answer, it's designated felony act petition. That's what they want on the file.
Designated felony act petition.
Petition.
Okay.
Okay, in that order. Designated felony act petition.
Okay.
Okay. 46. At any time in the proceedings, the court, upon motion of the respondent or court's own motion, may with the consent or blank and consent of blank, I think that's supposed to be of, consent of, I think that might be a typo, substitute a petition alleging that the respondent is in need of supervision for the petition that the respondent is a juvenile delinquent.
I'm going to say it's going to be both of them, presentment agency and the respondent.
Yes.
Okay.
Consent of, I think this word is supposed to be of.
It is.
But that word's of. Consent of presentment agency and consent of defendant. Substitute a petition alleging the person is in need of supervision. So they're going to substitute the 3 petition for the 7 petition.
The key in that one is what you want to underline there is that it says at any time in the proceedings.
Oh, really?
That's the key in that one, yeah.
At any time in the proceeding. So they could be like, no, let's just change this petition to a PIN's proceeding.
Yeah.
Okay, you go.
47. After conclusion of the dispositional hearing, the court, upon motion of respondent or the court's own motion, may in its discretion and with consent of blank substitute a finding that the respondent is a PINS for the finding that the respondent is a JD.
Oh God, I need to read that again. After conclusion of the dispositional hearing, what's the dispositional hearing again?
To find if
they needed to be detained.
No, this is the one at the very end. Like if he's gonna go to foster care or jail.
Oh, foster care, right?
Yeah.
Foster care is linked with dispositional hearing, right?
Yeah, because then they go to the permanency hearings after that.
Okay, so after the conclusion of dispositional hearing, the court, upon motion of the respondent or the court, may in its discretion and with consent of the presentment agency.
I think it is presentment agency. You want to look at your answer key?
Look it up. Number 47. Respondent. Consent of respondent.
Oh, okay. Because this is after. Okay. All right. Oh, I. You know what? That makes sense because I just was reading the question, like it's. I was thinking if the respondent made the motion, but if the court makes its motion.
Yeah, I get it.
All right, so that one, put a star next to that one.
Finding the respondent is so in other words, to wrap it in a nutshell, in order to change it to a PINS, the respondent has to consent. Is that right?
Yeah. That's why I told you the
key words in this is after the conclusion of the dispositional hearing.
Yeah, that's why I told you the other one is the keywords are at any time.
Okay, so this one is after the dispositional hearing. This one's on either, again, upon motion of the respondent of the court. So both of them is motions of respondent in court. But the one, anytime after the proceeding, is consent of presentment agency and respondent.
Yeah, now in your
But
question
after the
48,
it's only the consent of the respondent.
in your question 48, you should say in that one, prior to the conclusion of the dispositional hearing, who must
Oh, okay.
consent?
So let me just redo that again. So basically, after the conclusion of the dispositional hearing, only the respondent has to consent.
And the court.
Oh, and the court. Okay, so my question 28 says who must consent to the conversion of a juvenile into a PINS after?
Before.
Oh, before what?
The
Before what?
before the conclusion of the dispositional hearing.
Hold on. Conclusion of dispositional hearing.
And then your answer key, which is probably all three of them, would be right.
Oh, but if it was not all three, what if it didn't have that?
Well, I have that next in question 49.
Oh.
See? Okay, question 49. After the conclusion of the dispositional hearing, who must consent to the conversion of a JD petition to PINS? A, respondent, B, presentment agency, C, court.
Who must consent to the conversion after a dispositional hearing?
Right.
The respondent and the court.
Yep.
That's A and C. Yep, I got that. And the first one is A, B, and C. This is before the conclusion, right?
Yeah, so you should add in your question 48 before conclusion of the dispositional hearing.
After, and this was before.
Yes.
So if it's before,
It's all three.
and if it's after, just the respondent and the court.
Yep.
Oh, Jesus Christ. Okay. Hope they don't ask that. At any time before or during the fact-finding hearing. Now we're in the fact-finding hearing all of a sudden. I don't know how where fact-finding hearing comes in, but the court may, upon application of blank, and with notice to the respondent and opportunity to be heard, order the amendment of a petition with respect to defects, errors, or variances from proof relating to the matters of A, form, B, time, C, place, D, names, when such amendment does not tend to prejudice the respondent on the merits. Upon permitting the amendment, the court must, upon the application of the blank, order any amendment which may be necessary to accord the respondent an adequate opportunity to prepare his defense.
Okay, so this is when the presentment agency makes the motion. They can
The application of the presentment agency.
application of presentment agency. They can amend the petition for everything except and there's there's a list that I bet is the same as fucking the CPL.
I don't know if it's the same as CPL, but it's in my next question.
Oh, okay.
It may be the same as CPL, but if you want me to find it, I'll go to my CPL questions right now and find it.
Yeah, because I think it's probably.
You know what article it's in? This is amendment. You can't amend something. Do you remember where that is?
Oh, you know what? I'm looking at it. It's not this. It's missing something that's not in the CP. That's in the CPL.
It's 5 things you cannot amend.
Yeah. Okay.
One is to change the theory and theories.
The theory or theories of the prosecution.
Right.
Failures.
Oh, I know what it is. Misjoinder of defendants.
Yup.
I just remembered. It's misjoinder of defendants and misjoinder of offenses in criminal.
Yeah. Now the one that's missing in family court is misjoinder of defendants.
And offenses. Oh.
Crimes. No. That's in
right.
there.
They call it crimes in family.
Yeah. It's these are.
So the two that's missing in family is misjoinder of offenses and theories and theories. The theories.
Yeah, so then this one it's only 3, and in criminal
right.
it's 5. So let's just go over it again.
Remember that.
All right, let's just go over it again. So the ones that are in criminal are theory or theories of the prosecution, failure to state a charge or state a crime, legal insufficiency of factual allegations, misjoinder of defendants, or a misjoinder of offenses. And in family court, it's. Do you want to say the ones that are in family court?
Okay, family court is if it fails the theories or the theory or the theories, misjoinder of defendants, misjoinder of
Respondent.
offensive.
No. It's not. That's not in there. That's not in family court.
Wait, I thought I was doing criminal.
No, I just did criminal.
Oh, I'm sorry.
That's all right. That's okay.
I have it right in front of me. It's failure to charge a crime, legal insufficiency or factual allegations, and misjoinder of crimes.
Right. So in
And
criminal,
they
there's
can do it for a form of time, place, and names.
yes.
Okay.
So we're gonna get that.
I hope they ask us that question.
Me too, because I'm just gonna remember it's 5 in criminal and it's 3 in family, and
Right.
the one in family seems to be written by a 5-year-old, and the one in criminal kind of is written nicely.
All right. Well, that was your question. 51.
Yeah. So you go.
After a petition is filed, the court may cause a copy of the petition and summons to be issued. So they serve the petition and summons, right?
Yep.
Because I don't remember what you serve. I haven't done civil in so long, I can't remember what gets served. I remember you serve the petition only in what?
In a special proceeding. Wait, no, you file just the petition, but you have to serve the notice of
You file
petition
the petition only in what? A special proceeding?
in a special proceeding.
And in the other one, you file the petition and the notice of petition?
Yeah.
What?
Now in this one, this is the only place where I guess you're filing a petition and summons is in family
I can't
court.
wait to get to civil so this can come back to me because I can't remember it.
Yeah, it's gonna come. It's so much easier than this.
Okay, after a petition has been filed, the court may cause a copy of the petition and summons to be issued. They don't even say served, they say issued.
Yeah.
Requiring the respondent personally and parent personally legally responsible or the resides with to appear for the initial appearance. I gotta underline initial appearance, right?
Yes.
At a time and place named. The summons shall be signed by.
Shit.
Oh.
Shit.
I'm gonna guess. The
Okay, you
summons
guess.
has to be signed by the presentment agency.
That's what I would guess that but who's the or? The
Not
clerk?
the clerk.
Is it the clerk?
Oh, I bet you it is the clerk.
Is it the clerk?
Let me look. The clerk and the presentment agency. Hold on. No, you're gonna be so mad.
What is it?
A judge or the clerk of the court.
Fuck. All right. Shit. All right. We got to star this one.
Fuck, I'm starring that one.
Also, because I don't know how I'm going to remember. It's so weird. Judge. Oh, judge would sign a fucking summons? That's weird.
That's why when it said the court, I was like, is it the court?
Ugh.
But
All
why
right.
would the court sign a petition?
I don't know. All right. 53. Service of summons and petition for JD shall be made at least blank before the time stated for appearance.
Okay, so wait, service. I want to underline summons and petition again because those go hand in hand.
Only
Shall
in
be
this.
made by delivering a true copy at least blank days. I'm going to guess, but I know I'm probably wrong. Summons and petition in JD.
I think I'm going to guess too. So before you say it,
I'm
no, you
gonna
you go
say-
first.
I'm going to say 24 hours.
I think you're right.
Really?
Yeah. Hold on. Let me look it up.
You know what? I have a chart here with all the service on it. Let me look at my chart.
Okay.
JD, service, 24 hours.
Yay. Okay.
Okay, so can I just give you a sidebar here?
Yeah.
Service in Article 10 is also 24 hours. Service is in Article 8 is 24 hours. And I have service with a question mark in Article 7 with 24 hours.
Oh.
But Article 6, how much is service?
20 days.
Yes! How do you know that?
Because it's in the rules.
So maybe I will get some of those rule questions right.
Yeah, it's very repetitive in the rules.
Okay, so basically, is the 24 hours for the pins?
Fuck, I thought I don't remember the pins. I didn't read the rules for the pins yet. I only did article.
My chart is great because as we do something, I can go through the chart and say what each one is. Okay, great. Okay.
Wait, all right. So what is
Can I take a picture of
pins?
this chart and send it to you?
Yeah, go for it. What is pins?
You're gonna die when you see it. It's the best chart ever. I don't know if you're gonna wait, hold on. Let me take a picture of it and send it to you. When I found it, I'm like, oh my god, I love this chart. Wait, I gotta take a picture of it. And every time I do something, I kind of refer to the chart.
You're texting it to me, right?
Yeah. I'm gonna text it to you right now. But
Just so you know, our video is already an hour and 2 minutes long.
But you edit it, don't you?
I'll probably edit it before I post it, but
Okay.
I haven't, like, let me pause it for a second. Hold on. Yeah, you go.
If after reasonable effort, personal service is not made, the court may at any stage in the proceeding make an order providing for service in any manner the court directs. True or false?
True.
Right.
All right, 312.2. The court may issue a warrant directing that respondent personally appear or other PLR or where he resides be brought before the court when a petition has been filed and it appears that, and then this could be all of these, and there's 5 of them.
Mm-hmm.
Summons cannot be served.
Okay.
Yes or no?
Yes.
Person has refused to obey a summons or a family court appearance ticket.
Yes.
Respondent or other person is likely to leave the jurisdiction.
Yes.
A summons in court's opinion would be ineffectual.
Yes.
Or E, the respondent failed to appear.
Yes.
Yep, it's all of them. So all 5.
Yep. Upon issuing a warrant due to respondent's failure to appear for a scheduled court date, the court shall adjourn the matter to a date certain within how long for a report on the efforts made to secure the respondent's appearance.
I don't know this one. Should I guess?
Issuing a warrant due to respondent's failure to appear for a scheduled court date.
I'm gonna guess.
Well, they're just kind of like putting it off the calendar, right? They're just adjourning it to see if he shows up. So it's like on the warrant wall. Is that like where it goes?
I don't know. I'm gonna guess 3 days.
So upon issuing the warrant,
That's probably wrong, but I'm guessing it.
they're gonna the report. Okay, so for a report. Oh, so they need a report. I think that's an important word in this question. A report on the efforts made to secure the respondent's appearance. I'll look at the answer. Let's say 30 days.
What?
30 days.
Oh my God! Put a big star next to that one.
Yep, 312.2. 312.2, 30 days. So upon issuing a warrant, due to the respondent's failure to appear for a scheduled court date, the court shall adjourn the matter to a date certain within 30 days for a report on the efforts made to secure the respondent's appearance. Okay, so I'm guessing that he doesn't show up to court, so the judge says warrant ordered.
So it's like a control date. It's like a control date?
Yeah.
Okay.
Warrant ordered, and then the clerk will put it on for the next month.
Got it.
A month. So if we think of it that way, I think we can get it.
I hope so.
It's also for a report, so I guess the report in that 30 days, what did you do? You know?
Yeah, like have you looked for him or no?
Yeah, did you find a little rat bastard or not?
Yeah.
All right, go.
Okay. Sorry, I got up to put the air conditioner on. I was starting to get like sweaty in here. 57. A petition or account is defective when A, it does not substantially conform to the requirements stated in 311.1 and 311.2, provided that a petition may not be dismissed as defective, but instead may be amended, but instead must be amended when the defect or irregularity is the kind that can be cured and where the agency moves to so amend. B, allegations demonstrate the court does not have jurisdiction of the crime charged. C, the statute defining the offense charged is unconstitutional or invalid.
It's all of the above.
Yeah.
I think it's just something I'm just going to have to keep reading.
I feel like we're going to recognize that.
In the first one, what's important there, does not substantially conform to requirements, right? That's the thing. Does it?
It's basically defective, and it can't be amended.
I underlined the word defective too. In the second one, what's important there? Jurisdiction does not have jurisdiction.
That's it. Jurisdiction.
Does not have jurisdiction. And then the third one, statute defining the crime is unconstitutional. That's the word.
Or invalid. Or invalid.
Okay, so those are the 3 things.
Yep.
Substantially defective, no jurisdiction, or invalid. All right, that's easy.
Yeah.
Okay. An order dismissing a petition as defective may be issued upon motion of blank or blank. I would say presentment agency or respondent.
I'm going to say it may be all three of them.
Oh my God, you're gonna die. It's just the respondent and the court.
Oh, okay.
So, order dismissing a petition as defective. Oh, I guess that makes sense because the presentment agency, if it's defective, they're not going to want to dismiss it.
No, they would just not present it, I guess.
They would just kind of try to.
They would like send it back to probation service.
Yeah. All right, you go.
Or whoever drafts it, their legal department, and say redo this. Motion to dismiss. Wait, did we skip one? How did I end up on the evens?
No, you're on number 59. Motion.
Oh, okay. Motion. Oh, this is why I fucked up. I read the wrong question.
Oh.
Motion to dismiss petition in the interest of justice may be made by.
Oh, it's all three.
Yeah. So,
Okay, so then that's a really good thing you messed up on that because you have to keep in mind if it says in the interest of justice,
it's all of
it's
them.
three. But if it's defective, it's only the court and the defendant.
Right, because the presentment agency is not going to admit it.
So that was a good fuck up because it kind of made you realize that
Yeah.
defective, it's only two. Interest of justice, it's three.
Uh-huh.
Okay.
Okay, next. You go.
Motion to dismiss a JD petition brought by a presentment agency or respondent must be in writing and may be filed at any time subsequent to the filing petition. Notice of motion shall be served upon opposing party not less than blank days prior to the return date. Answering affidavit shall be served at least blank days prior to the return date.
It's 8 days.
Uh-huh.
And is it 2?
I think you're right. I think it's 8 and 2.
I think it's the same as civil.
Okay, awesome. That's great. Yep, it's 8 and 2. It's
All right,
birthday.
good.
It's my birthday, August 2nd.
Yep, so it's the same as civil, which is your birthday also, 8 and 2.
Awesome. All right, so those are motions to dismiss. Okay?
Yep.
Okay, you go.
Okay, so I'm up to
61.
61. Where petition alleges respondent committed a designated felony act. The court may at any time prior to entering a finding pursuant to 352.1 with the consent of blank order the proceeding adjourned in contemplation of dismissal for a period not to exceed blank.
All right, it's 6 months, right?
Yeah.
And it's
Whose consent?
of, I know marijuana, you need the consent of the respondent, right?
Yeah.
I think it's the consent of the respondent in this one, too.
I think you're right.
61, let me say. Consent of the respondent in 6 months. Let me look on my chart that I sent you. That we're talking about ACOD. You see my ACOD column?
Hold on, let me get to it. Oh, damn it.
It's 6 months.
I just cleared
Don't worry.
something.
Oh, I can send it to you again.
No, I have it.
Oh.
Because I saved it. Here it is.
It's 6 months, but I don't have who has to consent. Should I put it on my chart?
Hold on.
Respondent consent. I'm going to put respondent consent in that box. See
Okay.
where it's in 6 months?
Yeah.
I'm going to put under respondent consent. And then when we see the other ones, we'll see who has to consent. See where it says 6 months ACOD for 3, 6 months ACOD for 7, 1 year for 8, 1 year for 10. 1 year for pot, 6 months for CPL, 6 months for CPL plus kids, 3 and 7, and adults plus pot is 1 year.
All right. Yeah, this
All right.
chart's good.
All right, next.
All right, you go.
If the respondent is juvenile, if the respondent in a juvenile delinquency petition is detained, the initial appearance, I'm just going to underline initial appearance, shall be held, now they were talking about if he is detained, shall be held no later than, can I just stop for a second? Didn't we do a question before on if he's detained and time frames, or is this the first time we're doing a question on if he's detained and time frames?
No, we definitely did this question already.
No, we didn't.
Not this exact question, but it was this
What was that
substance.
other question? Was that all right? We'll have to go. We'll have to.
Well,
All right.
hopefully the answer is the same.
I thought it was the initial appearance question. I know I underlined initial appearance. Let me
The
just back
other
up.
the other one was
Wait, I have it right here. Hold on. I know I underlined it. I should be able to find it.
it's 72 hours, right?
Was that the answer?
Well, look up the answer for this one first.
Okay, hold on.
If the respondent is detained, the initial appearance shall be held no later than 72 hours after petition is filed, or next day court is in session, whichever occurs first.
Okay.
Is that what this says?
72 hours, you're right, yep.
All right, so then it's the same.
And if the respondent is not detained, the initial appearance shall be held when?
Is this
And
14
the other one, it
days?
was 14 days, whatever we did, remember?
Yeah, please be 14 days again.
Nope.
10 days?
Nope, you're going to die. It's 10 days, but it's as soon as practicable and absent good cause within 10 days after the petition is filed.
Okay, so 10 days.
I have to put a star next to that one. So what was the other one with 14 and 72? Let me go find
That was the appearance ticket. Was that the
appearance ticket? That was, it has to happen. Oh, if he's detained, it has to be within 72 hours, and if he's not within...
No. If it was a designated felony, it had to be 72 hours. And then if it was not a designated felony, it was 14 days.
But for what was that, the appearance ticket?
I think that was the appearance ticket.
They would have an appearance ticket for a designated felony?
I think so, yeah.
You know what? Let me just find that question, because that's going to drive me nuts.
Okay.
The answer was 14 and... what was it, 72 and 14?
Yeah.
It's question number 27 on the test. You ready?
Yeah.
It is if a crime alleged to have been committed, you're right.
That's
It's a
okay.
felony after the issuance of an appearance ticket. 14 or 72 hours if it's a designated felony, and if it's not, 14 days. Now, the question we just did was for, what was the question that we just did? Oh, for the initial appearance, if he's detained. The initial appearance?
Yeah, so this is different. Well, it's not really different, but because the appearance...
The initial appearance what? After a summons is served? Or the initial appearance what?
I think the other one was for the initial appearance. The only difference was it was a family court appearance ticket to appear at a probation service. This one is for him to appear in court.
Okay, but so question 50, the one I told you was question 20. 28 was it? 27 and 28.
So
Yes.
either detained.
Question 27. It says a return date shall be. It doesn't even say to appear where.
No, I know. It's going to tell you later.
Oh, okay. All right. So listen, all I have to remember is after the issuance of an appearance ticket, if it's a designated felony, it's 72. If it's not, it's 14.
Yes. And if the offense is unspecified, but they're telling you he's detained, it's either 72 hours, next day court's in session, or if he's not detained, 10 days.
Or as soon as practicable.
As soon as practicable.
Right, and absent of good cause
within 10 days. So as soon as practicable, right. But in absence within 10.
So that's 72 hours and 10 days. I put a check next to that one.
Yeah.
And the trick to that one is that it doesn't say designated felony.
No, this one has nothing to do with what he's charged with. It just says detained or not detained. The other one.
Right, an initial appearance.
Yeah.
Okay, moving on. You go.
Okay, next. 63. The initial appearance in a JD proceeding may be adjourned for no longer than blank or until the next court day, whichever occurs first, to enable an attorney for the respondent to appear.
All right, well, if we go by the question before that, it says the initial appearance. Oh, they're talking about an adjournment.
An adjournment.
Oh, so he shows up and he needs an adjournment for an attorney, right?
Yeah.
So this is adjournment for attorneys.
Yeah.
I'm going to guess. Are you going to guess, or do you know it?
No, you guess, because it's your turn.
I'm going to guess He needs to get an attorney. Maybe the judge will give him. Fuck. It's not gonna give him too long, right? Because it's. I don't know. 2 days. I don't know. How long?
I'm gonna say this is an adjournment we're talking about.
An adjournment so he can come back with an attorney.
I'm gonna say again 72 hours.
Yup. How'd you know that?
I just guessed because of the way that they keep talking about it.
Okay, so if you're mentally ill, mentally retarded, or developmentally disabled.
Alrighty.
Those are the two charges. Okay, I go. Next question. I think the key is that order of examination. Upon the receipt of an examination report, court shall conduct a hearing to determine whether the respondent is an incapacitated person. A, respondent. B, respondent's attorney. C, the presentment agency. D, the Commissioner of the Mental Health and Commissioner of Developmental Disabilities shall be notified of the hearing at least blank days prior to the date of the hearing and afforded an opportunity to be heard. Oh my God.
Oh, I don't know this one.
I don't remember. Okay, so let's read again. Upon receipt of the examination report. So the court's going to get a receipt from the examination people saying whether or not he's one of those three things, right?
And the court has to have a hearing, and all these people have to be notified about the hearing at least how many days before.
So I also have to remember also the Commission of Mental Health is included in that.
Oh, I think that was
So is it 30 days?
Oh, I have no clue. I'd be
If they're
guessing.
going to give all these people notice, they're not going to schedule it probably so quickly. That's my reasoning, but I could be wrong. I'm going to guess 30 days. 74.
All right, yeah, I'll guess 45 days.
Oh my God, okay. Oh my God, you're going to fucking die.
20 days. What is it? 10 days?
5 days. My reasoning was so off.
Oh my
How am
God.
I going to remember this?
I don't know.
So the examination, the order of examination reports come back. The judge, the reports say he's mentally ill or whatever. He's one of those three things. The court shall notify those four people of a hearing 5 days prior to the hearing and afford an opportunity to be heard.
Oh God, okay.
So they got 5 days. I got to put a check next to this one.
Yeah, that's ridiculous. 5 days.
All right, you go.
75. If the
We're
court...
3/4 way through the test.
All right. If the court finds that the respondent is not an incapacitated person, it shall continue the delinquency proceedings. It shall schedule a hearing to determine whether there is blank that the respondent committed a crime, an act which would be a crime if committed by an adult.
Wait, you know what? I think my test is missing something. Read that again from how it's read in the test. Read it again.
Yeah, if the court finds that the respondent is not an incapacitated person,
Okay.
it shall continue the delinquency proceedings.
Okay.
If the court finds the respondent is an incapacitated person, it shall, wait, I just screwed up. Schedule a hearing to determine whether there is blank that the respondent committed an act which would constitute a crime if committed by an adult.
I'm going to guess that just fits in there. Is it probable cause?
That's what I'm going to guess too.
That there's probable cause that he committed a crime. Okay, so question number 75. The answer is...
It's got to be probable cause. It's in the next question.
Probable cause to believe.
All right. So
JD, if he's incapacitated...
well, this says no. That was if he's not incapacitated, it shall continue the delinquency proceedings.
Right, but
if he is incapacitated,
schedule a hearing.
It'll schedule a hearing. And then you go next with the next one.
If the court finds that there is probable cause to believe that the respondent committed a misdemeanor, the respondent shall be committed to the custody of A, the appropriate commissioner, for a reasonable period not to exceed blank, the court shall dismiss the petition on the issuance of an order of commitment.
Wait, now is this saying that he is incapacitated? Or this has nothing to do with that?
I don't know. Well, it's in the same section.
All right, so maybe this is saying if he isn't, I don't know.
We'll go look it up. 322.2.
All right, I'm going to look it up.
2, 3, and 4.
All right, I'm looking it up right now. 322.2. I hate this article so much. I cannot wait till we're done with it.
But you know what? I'm going to feel so good after we do it.
Once I know this one, I feel like nothing could be as bad as this, except maybe like 440. All right. Okay. If the court finds the respondent is not incapacitated, it continues the proceedings. If the court finds that it is incapacitated, they have the probable cause hearing. If the court finds there's probable cause to... Okay, so yeah, this is the 90-day thing, but it doesn't say anything. Yeah.
Hold on 1 second. Matt, somebody, hold on 1 second. Hold it. Okay, Matt, you there?
Yeah.
Okay. Stephanie Bruder ass dialed me by accident. Hold on the other line. Okay,
Oh.
so good.
Okay.
She doesn't know she's on hold, and I don't know how to end the call.
Oh, so just put me on hold and tell her.
No, she doesn't even know that I'm on the other line. I hear everybody in the background at her house.
Oh, that's hysterical.
So I'm just going to leave it. It's on the other line, on hold. Okay, so go ahead.
All right, so then we have in October 1st, I think that they forgot to say that this should have, in subsection 4 here, this I think should have been like a little sub A, like another A, because I think they're saying that if the court finds he's incapacitated, the court shall have the hearing.
Right, because they didn't really like really.
No, they did. This is so badly written.
Like, all of a sudden, they talked about an incapacitated person, and then they just forgot all about him.
Yup.
Right?
Yup.
All right, so let's just go on.
I'm telling you, the people that wrote this book hated it too.
They're like retarded. All right, let's just say though, because wait. You're gonna be really bugged out. Did you see the next question after this?
No, not yet. Why?
Okay, so this question talks about if the court finds that there's probable cause to believe that the respondent committed a misdemeanor, he shall be committed to the custody of the appropriate commissioner, period, for a reasonable period not to exceed how long?
This is 90 days.
Hold on, let me look.
It is, because it's all, the times are all messed up.
90 days, how do you know that?
Because when I was going through this, it said it had 90 days in 1 year, and I remembered that in criminal, with the adults, the times were shorter.
What's the times in criminal?
One was 30 days.
I don't remember this.
We're going to have to go over that whole test again.
Okay.
Because the
Wait, are you talking about the order of commitment in criminal?
The commitment order was 6 months, right?
The commitment order is 30 days. No, it's 6 months.
6 months.
It's 6 months. And
Okay.
This is 90 days.
Yeah, but this is only for a misdemeanor. Keep going. 77. If the court finds reasonable cause...
77 is effective October 1st, by the way.
Yeah.
You have the old book or the new book?
This is
You have my question, right?
Yeah, if the court finds there's probable cause to believe the respondent committed an act that would be a felony, it shall order respondent committed to the custody of A, Commissioner of Mental Health, or B, Commissioner of Office of Developmental Disabilities for an initial period not to exceed blank from date of such order.
1 year?
Yes.
Okay.
For some reason, I remembered the adults being 6 months.
So it's how much? 60 days or 90 days? What was it?
This one is 90 days in 1 year.
What was the other one? Oh, 90 days. Okay.
Yeah, 90 days. Such
Okay, so
period may be extended annually upon further application to the court by the commissioner having custody or his designee. Such application must be made no more than blank prior to the expiration of such period.
Wait, I think I remember from doing this, typing the test out. 60 days?
I think you're right. I think it's 60 days.
Yes, 60 days.
Awesome. Okay, so then it goes on. The commissioner must give written notice of the application to the respondent, his lawyer, the mental hygiene legal service, if the respondent is in a residential facility. And upon receipt of such application, the court must conduct a hearing to determine the issue of capacity. If, at the conclusion of the hearing, the court finds he's no longer incapacitated, he shall be returned to the blank for further proceedings.
Family court.
I didn't know that, but cool.
Family court.
Okay. If the court is satisfied the respondent continues to be incapacitated, he shall authorize continued...
Wait, I got a question for you.
Yeah.
Why are they returning to the family court? Where is all this shit going on?
I have no idea. This is all
Wait,
just...
Did that just hit you?
Oh, yeah, I was thinking that as I was reading...
They're going to return to the family court. Where are they right now?
I have no idea.
Them? Where the fuck are these people? Seriously.
I don't know.
Is this the probation service is doing this?
Oh, no, wait a minute. You know where he is? He's in the custody of the mental health people. They sent him to, like, the nut house, and now...
But they're talking about hearings and shit. As far as I'm concerned, that's going on in a courthouse.
I know. You would think so.
Right? Okay, so go ahead.
All right. So he's being returned to the family court for further proceedings. If the court is satisfied the respondent is still incapacitated, the court shall authorize continued custody by the commissioner for a period not to exceed blank.
Another year? I don't know.
I don't know this one either. I forgot.
It's 1 year.
All right, so another year. Such extension shall not continue beyond a reasonable period of time necessary to determine whether respondent will attain the capacity to proceed to a fact-finding hearing in the foreseeable future, but in no event shall continue beyond the respondent's blank birthday, or if the respondent was 16 when the act was committed, beyond his blank birthday.
Did we do this, or I'm just remembering it from typing it out? Is it 18 and 21?
Well, there was an 18 and 20 before.
It's fucking 18 and 20 again.
I don't know what this one
is. I just looked it up.
Oh, okay.
So can I read it with those dates in it?
Yes, go ahead.
Such extension. So extension, we're talking about what? An extension to be committed for another year?
Yeah.
Such extension shall not continue beyond a reasonable period of time necessary to determine whether the respondent will attain the capacity to proceed to a fact-finding hearing in the foreseeable future. So in other words, we don't know if he's ever going to be normal to be able to have a regular hearing because he doesn't understand anything, right?
Yes.
But in no event shall continue beyond the respondent's 18th birthday, or if the respondent was 16 when the act was committed, beyond his 20th birthday.
Okay, and then it goes on to, now we have here Europe.
Okay. Oh my god, I had to put a big fucking check next to this one. This whole test has checks next to it. Oh, this one's effective October 1st, 2018. I have a little typo here. Hold on. If a oh my god, another typo. If a respondent is in the custody of the commissioner upon the respondent's blank birthday, or if the respondent was at least 16 when the act resulting in the respondent's placement was committed beyond the respondent's blank birthday, the commissioner shall notify the clerk of the court that the respondent was in the custody on such date, and the court shall dismiss the petition.
This, I think, I'm going to guess, because I'm not sure.
It sounds fresh.
I'm going to say that I don't know this one, so I'm guessing. Is it like the commissioner of mental health or something?
No, it's 2 birthdays we're looking for. So the question is, if the respondent is in custody of the commissioner, upon the respondent's what birthday? It's like 18th, 19th, 20th, 21st birthday. Or...
Oh, this is the same question. 18 and 20.
No. It's
No?
18 and 21 on this one.
Oh, what the fuck?
I I know.
These people, I swear.
know, Mary. This one
Wait a minute. So does that mean that question 77 is not in effect anymore?
I don't know. The one it's not the same question though, because the question before it was about. Hold on, let me go to the question before it. The one before it was about extensions.
And this one is about what?
This one is about being in the custody of the commissioner.
Oh my God. Okay.
Okay, so let's make a little note at the bottom of the paper.
All right, I'm going to I want to look at this in the book. What section is this again?
Which one do you want to look under?
I want to look at 77 to make sure that I understand what
Question
that.
77. Let's go over that one first. It's in Article 322.2,
Okay.
subsection little a. You see little a?
Yeah.
Effective October 1st, 2018.
Little
It
a.
should be at the very bottom where it talks about extensions.
And then it says effective C contingencies until October 1st. All right, now I'm looking at the old one. Old one. Because you do this out of the gray book, so that book is usually good.
Yeah, mine's 2000. Mine's a brand new book. Mine's a 18 book.
Yeah. All right, so the one that was repealed is the other little b. The little b, and this one is effective October 1st. That the respondent was in his custody on the date. I'm totally confused by this. Look at the two little b's right next to each other.
Wait, on which one? 322.2?
Yeah, and there's a little b.
322.2. Okay, so I see the B where it says effective until October 1st, 2018, right?
Yep.
I put a big X through that.
Okay, so that was the second one, the longer one.
Right, the second one is the one that my notes are on.
Okay, now in my app, because I'm on the app, it's different, and this is what it says for the one that's effective October 1st. It says, if a respondent is in the custody on the 18th birthday, the commissioner shall dismiss the petition. And then it's saying that the other one about the 21st birthday is expired.
Wait, back up a second. That whole thing that you just said, he shall dismiss the petition, what question is that on my test?
This is not a question. I'm just looking at a book right now.
Oh, okay.
Okay, so what I'm looking in the book, and it says that little a, effective until October 1st. So I'm crossing that whole thing out in my brain.
The little a, right.
Okay.
That says that little a, effective October 1st, 2018.
Okay, I have that little a, and now I was looking in the little a, and I see only 18th birthday.
Oh, in that little a, you only see 18th birthday?
That's what I'm seeing. Now, I don't know.
Where is it far down? Where is it? Where I want to find it?
It's at the bottom.
And I'll follow along while you're reading it?
Okay, so I'm now looking at the one that says October 1st is effective until October 1st, and then the next one says effective October 1st. So,
yeah,
okay, so I'm doing that one only.
I'm going to read along with you and see what my
All right, it's a very long thing, so bear with me.
Ahead.
If the court finds there is probable cause to believe respondent committed a felony act, it shall order the respondent committed to the custody of Commissioner of Mental Health or the Developmental Disabilities Guy for an initial period not to exceed 1 year from the date of such order. That it may be extended annually upon further application to the court by the commissioner having custody to his or her designee. Such application must be made not more than 60 days prior to the expiration of the period on forms that have been prescribed by the fucking chief administrator. At that time, the commissioner must give written notice to the respondent, the counsel representing the respondent, mental hygiene legal service if respondent is in a residential facility. Upon the receipt of the application, the court must conduct a hearing to determine the issue of capacity. If at the conclusion of the hearing, the court finds the respondent is no longer incapacitated, he shall be returned to family court for further proceedings. If the court is satisfied respondent is still incapacitated, court shall authorize continued custody for a period not to exceed 1 year. Such extension shall not continue beyond a reasonable period of time necessary to determine whether respondent will attain capacity to proceed at a fact-finding hearing in the foreseeable future, but in no event shall continue beyond respondent's 18th birthday, or if the respondent was at least 16 when the act was committed, beyond the respondent's 21st birthday. And then it continues on with the other B's.
21st birthday, right? And what did I have in my question?
You have 21st birthday. That's why we're making
21st. I had it right.
Yeah, what we're trying to figure out is what we're trying to figure out is what the hell is different.
Wait, I have the wrong answer in my answer guide.
You do?
Wait, I do. Wait, because it said 21st birthday, right?
Yeah.
In my answer, I have where it says such extensions, right?
Yeah, the extensions.
I have 20th in my answer key.
21st. Okay.
So let me fix that. I'm so glad we did this.
Now, in your book, and it says the same exact thing in your book, right?
21st.
Okay.
Okay, let me
now
fix
what?
it.
Now look at the
And
expired one.
And then the next question is 18 and 21.
And then let me ask you a question. In the one that says,
I'm so glad you caught that.
well, in the expired one, I can't even find the 20th birthday in the expired one.
Oh wait, what do you mean?
So you know how you have 20th birthday in there?
No, I had 21st.
So that was right then, 21st.
Yeah, I had a typo. It was 21st.
Oh, you just had a typo.
Yeah.
Oh, okay.
That says effective October 1st, 2018, that you just read.
Yeah.
Is correct. Is correct.
Okay.
That's just said to you. I'm so glad you caught that, because I was like, why is one 20 and the other 21?
All right, so that makes sense now.
We go to the next question, and which is effective October 1st, 2018, and that's in little b.
That's a small one.
Yeah, you see the little b underneath?
Yes, so they changed it from 18 to 21. That's the difference.
And
because
this was the same, right? 18.
Yeah, because if you look at the little b, it's talking about an 18th birthday. All they have to do is notify that the commissioner was in his custody.
They added the 21 in it.
They added the 21 in this one. About the at least 16, when the respondent was at least 16 years of age, then it goes to the 21st birthday. The previous one just had the 18th birthday.
Okay. So it's 18 and 21.
Yup, and it's 18 and 21 in both of them.
Oh God, I should really put a star next to that one.
Yeah, I'm glad we took the time to figure this out.
Yeah, well, that was my big mistake because I had a typo. So that's why I'm glad I'm doing this with you, because I don't have the time to do this all by myself.
No, I know.
It's a lot of fucking work.
All right, so let's go on to C. I think we should just keep reading this section, and then we'll go back and do the
I
questions.
think I'm getting it because it's all in order, and then I think hopefully when we get to the few other sections, it'll start clicking. I don't know.
Yeah, now let me just read to you little C, because this one, it looks like has not been changed at all.
Okay.
All right, it says, little c, if the court finds there is probable cause to believe there was a designated felony act, the court shall require that treatment be provided in a residential facility within the appropriate office of the Department of Mental Hygiene. And and then it goes into D. The commissioner shall review the condition of the respondent within 45 days after he's committed. Yeah. And then he has to do a second review within 90 days after the respondent is committed, and then review them every 90 days.
Oh my God! Wait, we gotta go over that again. The commissioner is reviewing. What is he reviewing?
I'm in little c in 322.2.
Right.
Okay.
I'm reading it.
All right. So he's reviewing the condition of the respondent.
Okay.
And then 45 days later, or whatever, within 90 days, so the first two, the 45 and the first 90 days, they're measured from the time that he was committed. So it's not 45 and then he gets another 90 to do the second review. The first, you got it? And then...
Shall review the conditions of respondent within 45 days after the respondent is committed against the sheriff of the commissioner. He shall make a second review within 90 days after the respondent is committed to custody?
Yep, so the first two are measured from then. And then the next 90 days thing is that he will review the commissioner every 90 days, and they have to notify respondent, his attorney, and they get an opportunity to be heard.
But wait, so they're including that 45 days in that 90 days?
So this is how I think this works. So the commissioner is going to review the guy within 45 days of the commitment. All right, then he's got another 45 days to do a second review because
But they call it 90.
but they call it 90 because they're assholes. So
Oh my God.
yup, and then that's when the 90 days really, it's a real 90 days from the second review is a real 90 days.
I got it.
But the idea is if he did the first review, let's say he did the first review in 10 days, he's got 85 days to do a second review.
Oh, shit.
Okay?
I see what you're saying.
See what I'm saying? All right.
Yeah, within 45 days doesn't mean he has to do it in 45 days.
No, it just means he's got to do it within 45 days.
Right, and then if he does it within 5 days, he has fucking 44 days plus whatever.
Yeah, if he
45.
does it within 5 days, he's got 85 days to do it.
Right, okay. Got it.
80 days. I meant 80 before, but you get the idea.
You can read the next one because it's odd.
All right, so now, and we know that he's got to give written notice to all these fucking people, and the court's going to have a hearing, blah, blah, blah. Okay. All right, so next we have 79. If the court finds... Oh, we just did this one, but I'm going to ask you the question anyway.
81.
No, 81? Okay. This is effective October 1st, 2018. At the initial appearance, if respondent denies a charge contained in petition and court determines respondent shall be detained for more than blank pending a fact-finding hearing, the court shall schedule a probable cause hearing to determine the issue. So there's the answer to your question. They do not always have to have a probable cause hearing.
Is it what is it? When do they have to have it?
I don't know the answer to this
If
question.
the respondent denies the charge,
Yeah, I don't know the time rule here, but
I think it's 3 days and 4 days or something.
yeah, I think that sounds familiar. And then there was a 14 days somewhere.
All right, keep reading it.
All right. Such probable cause hearing shall be held within blank following the initial appearance or within blank following the filing of petition, whichever occurs
We
first.
better figure out these answers.
I think it's 3 and 4, but I don't know the first answer. I don't know the first answer.
Let me read it. At the initial appearance, so we're back at the initial appearance again.
And now we're away from the guy incapacitated. We're totally done with that.
Okay. All right. And so the initial appearance, and he's saying, I didn't do it. I'm not guilty. The court determines that the respondent is going to be detained because he is probably fucking guilty.
Well, he's denying it. It's not pleading. It's not guilty, not guilty. It's guilty, not. It's deny or admit. So just keep that in mind.
So he's denying it.
Denying
The
it.
respondent shall be, if the court determines that the respondent shall be detained for more than 3 days.
Is that the answer?
What?
Is that the answer?
Yeah.
All right.
Pending a fact-finding hearing, the court shall schedule a probable cause hearing to determine the issue. To determine the issue of what? If he's guilty or not?
I don't know. I guess, to determine if there's probable cause.
Okay. Such probable cause hearing shall be held within...
I think it's 3 days and 4 days here.
4 days. So wait. So if he's going to be detained more than 3 days...
This is so stupid. This can't be right.
Schedule the hearing.
Yeah, because if it's going to be, he detains more than 3 days, they have to have the probable cause hearing within 3 days. Is that what that is?
Okay, this is very strange because it says, if the respondent shall be detained for more than 3 days, the court shall schedule a probable cause hearing. The probable cause hearing shall be scheduled 4 days within the initial appearance.
So there's the 3-4 rule. Or within blank days following...
So, just say if the respondent is detained more than 3 days. Oh, so are they saying he's already been detained more than 3 days?
And all this is
no, shall be. It says the respondent shall be detained. He's not detained yet. It just says if the court determines that the respondent shall be detained for more than 3 days pending the fact-finding hearing, the court shall schedule a probable cause hearing to determine the issue. Such probable cause hearing shall be held within 4 days following the initial appearance or within, hold on.
4 days of filing the petition.
No. 3 court days.
Wait, that's the adjournment.
No.
Yeah, the adjournment is the 3 court days.
Oh, wait, you're right. I'm sorry, I skipped something.
It's this rule. This is how.
Go back and make sure.
It is. I'm telling you the way this rule works. With all this mumbo jumbo, it's 3, 3, 4, 3 court days.
No, wait. The first one is 3.
Then
the fact finding.
And the second one is 3.
Probable cause hearing shall be held within 3.
Yep.
You sure?
Positive.
Okay, so probably cause hearing will be held within 3 days. Okay.
3 days of the initial appearance or within 4 days of the filing of the petition, whichever occurs first. Then the adjournment for good cause, it's 3 additional court days. So like the other one is 3 days. So that means if his initial appearance is on Friday, they have to put it on for Tuesday. But if then on Tuesday, the attorney isn't ready or something, or then they can adjourn it for 3 court days.
So I'm gonna listen to you and not read it well.
Okay, so let me start from the beginning then. If the respondent at the initial appearance, if respondent denies a charge contained in the petition and the court determines that the respondent shall be detained for more than 3 days pending a fact-finding hearing, the court shall schedule a probable cause hearing to determine the issues specified in 325.3, which, what the hell is 325.3? Let me just make sure. 325.3. What?
You don't hear him coughing in here?
No, well, there's a lot of background noise.
Are you looking at me?
Yeah, what's that noise?
Wait, hold on. I'm actually rolling up. So I have to think on real quick. Are you looking up that other thing, whatever 3 something is?
No, yeah, I'm on it, but I can't really hear you.
All right, hold on. Okay, go ahead.
Okay. All right, so this is that the initial appearance shall be detained for more than 3 days pending a fact-finding hearing. The court shall schedule a probable cause hearing to determine the issues specified in 325.3, which I don't know what the fuck that is, but it's to figure out if a crime was committed and if the respondent committed it. All right, so that's what the hearing is for.
Okay.
All right, and then if they are not going to be able to have a fact-finding hearing within 3 days, then they have to schedule a probable cause hearing for within 3 days. 3 calendar days.
Okay.
Or 4 calendar days within the filing of the petition, whichever occurs first.
Oh my God.
Okay, then if for good cause shown, the court may adjourn the probable cause hearing for no more than 3 court days.
Okay, let me see if I can recite it back to you without looking at the paper.
Okay.
At the initial appearance, if the court determines if he denies a charge or denies the charges, is that it?
Yeah.
Okay, so at the initial appearance, if he denies any of the charges, the court is going to, and the court determines that he has to be detained. And if he has to be detained more than 3 days pending the fact-finding hearing, it will schedule a probable cause hearing within 3 days of something or 4 days of the filing of the petition.
3 days of the initial appearance and 4 days of
the initial appearance and 4 days of the filing of the petition, whichever is sooner. And then if they need an adjournment, it can be for 3 court days.
Yeah, so it's 3 calendar days, 4 calendar days, 3 court days.
Oh my God.
Okay, it's just a pain in the ass rule.
I recited it without looking.
Yep, you got it, and you're gonna remember it now. It's just,
That all has to do with the initial probable cause and waiting if he has to be detained.
Yeah, and like this is stuff I think that's pretty important because you're talking about a kid. He's missing all this school. Like you. Okay, then I don't know if this is in your test, but if not, we'll go back to it. So, Okay, the respondent may waive the probable cause hearing, but the fact the respondent is not ready for the fact finding shall not be deemed a waiver. And then let me
Wait,
just
say that again. I missed that.
all right. So let's say he's says he's not ready for the fact finding hearing. That's not a waiver of the probable cause hearing.
Okay.
Okay, and I just want to point something out because this is effective October 2018, which and this wasn't in here before. It says this is where when the petition is consisting of a removal pursuant to 725 of the CPL, and the respondent did not have a probable cause hearing or whatever. After the filing of the petition, the court must, however, exercise independent de novo discretion with respect to release or detention. So just because he in criminal court they ordered him detained, that doesn't mean that the judge can't be like, oh well, some other judge in Supreme already decided. They want the judge in family court to exercise independent de novo discretion with respect to release or detention.
Okay.
Okay, so just be aware of that if you recognize that language.
Okay. Even though it probably went over my head, but if we come across it again, let me know.
All right, yeah, we probably won't, but just remember that just because the judge in the youth part ordered him detained, that doesn't mean the family court judge can't release him. And if the youth part judge ordered him released, that doesn't mean the family court judge can't detain him.
Oh, okay.
Okay?
Family court has the final say?
Yeah, they want family court to exercise independent discretion.
Okay.
All right, now we can go to the next question, which I think is yours.
Do I need a check next to that one?
No, I think we're going to get this because you have it in, you could put a check next to 82.
Actually, 82 is the same question, right?
Yeah, so that's the short version of it, so put this check next to that one.
Okay. If after his initial appearance, a respondent in a JD proceeding is ordered detained, the court must schedule a probable cause hearing within 3 days of the initial appearance, right?
Yep.
Or within 4 days of filing of the petition.
Yep, you got it.
Sooner. Hold on, I just want to see my answer key to make sure I have it right. Probable cause hearing, initial appearance, filing of the original petition. We're good, girl.
Yeah. All right, listen, you're not going to bed yet or anything, right?